Welcome to LexiCast, a podcast designed to help you grow in your legal practice, with weekly updates on current topics, trends, and practical insights. Perfect for listening on the go. Let's dive in.
Welcome to the deep dive. Today, we're looking at how modern technology is completely transforming the way you communicate in legal practice. We really want to unpack this massive kind of invisible tension that's building between the modern client's demand for instant tap of a button speed.
And, your unyielding professional duty of competence and diligence.
Exactly. So to set the stage for you, I want to pull a really brilliant comparison right out of our source material. Picture a tale of two lawyers, right? First, imagine a sole practitioner back in the 1970s.
Yeah, the classic setup.
Yeah, he's got a landline on a heavy wooden desk, a dedicated secretary, a dictaphone. A client calls, they make an appointment for, next week. They sit down, talk. He takes handwritten notes.
Very methodical.
Extremely. He dictates a draft will, the secretary types it up the next day, and then it's dropped in the mail. And a few days later, the client actually reads it. It is a very slow, highly methodical rhythm.
Right, it took time.
But now, fast forward to our hypothetical 2025 lawyer. They might be sitting in a busy co-working space or maybe just at their kitchen table. A client pings them through a website portal.
And expects an answer yesterday.
Literally. The lawyer shoots back a pre-recorded video explaining the process. Then they jump on a quick Zoom call, feed the transcript into a generative AI tool to draft the document, and shoot it to the client for an e-signature on their phone.
The whole thing might take, 2 hours?
Exactly, not 2 weeks. Okay, let's unpack this. The 1970s lawyer had a built-in luxury that the 2025 lawyer completely lacks, and that is the luxury of time for contemplation.
Yeah, that built-in friction of the 1970s workflow, it automatically enforced a cognitive pause. You drafted letter, you went to sleep, you reviewed it the next morning before the stamp ever went on the envelope.
You had a chance to actually think about it.
Right. That pause allowed for human legal judgment to actually kick in. The shift we are seeing today is a fundamental shift in the cultural expectation of speed, and they are bringing those expectations to their legal representation. But here is the critical tension. While the tools have completely revolutionized, the professional minimum standards have not budged a single inch. Your fundamental professional duties like delivering services competently and diligently, adhering to Rule 7 of the Uniform Conduct Rules regarding plain language, acting with promptness, and crucially, maintaining meticulous record-keeping.
Which is huge.
It is. Those apply just as strictly to a hurried voice note sent from your car as they did to a typed, formally mailed letter on heavy bond paper.
So the underlying issue is that modern communication tools are inherently designed to bypass friction.
Which means they are inadvertently designed to bypass contemplation.
Right. So we've established that this demand for speed is eroding contemplation, which brings us to a massive, immediate minefield we really need to walk through, and that's instant messaging.
Oh, absolutely. It's everywhere.
Because your 2025 clients are so addicted to instant gratification, they are actively dragging you, their lawyer, onto casual platforms. They want to text you the same way they text their friends about dinner plans.
But bringing legal matters onto these platforms introduces severe security and record-keeping risks. I mean, let's look at the apps they're asking for. WhatsApp, WeChat, Signal, Telegram.
It's a nightmare.
The data sovereignty risks alone should keep any practitioner awake at night. Take WeChat, for example. The servers for that app are hosted in China and are subject to Chinese data laws.
Which is a massive red flag.
It's considered such a significant security vulnerability that Australian government personnel and defense forces are expressly banned from having on their phones.
Just banned outright?
Outright, due to the risk of data scanning and eavesdropping.
Wow. And, it's not just platforms hosted overseas. The sources highlight WhatsApp, which is practically ubiquitous here, and that's owned by Meta.
Right, and Meta is deploying generative AI to scan vast amounts of data across its platforms to enforce community guidelines.
Which people don't realize.
They don't. There are recent documented instances where business accounts on WhatsApp have been abruptly shut down without warning simply because an AI flagged something in the chat.
Just gone.
Exactly.
Yeah.
If you are running your client communications on WhatsApp, you do not own or control that platform. Meta can shut you out instantly. There is virtually no customer service to call and no right of appeal.
You lose your entire communication history in the blink of an eye.
Yep.
Let me stop you right there, because if a third-party AI is constantly ingesting the chat to check for community guideline violations, isn't confidentiality fundamentally broken? Are we looking at the destruction of attorney-client privilege?
That is the ultimate legal insight here. Under the third-party doctrine in many jurisdictions, voluntarily sharing information with a third party, in this case, an algorithm scanning your text, can potentially waive privilege.
That is genuinely terrifying.
It is. If you are discussing highly sensitive litigation strategy on a platform that actively scrapes its own data, you are playing Russian roulette with your client's legal protections.
And yet, I know lawyers who try to work around this. They think, oh, I'll just take screenshots of the important text and save them to the official file.
Oh, no.
Right. Let me just push back on that habit right now. Using screenshots to document instant messaging is like a doctor keeping your medical records on cocktail napkins.
That's a great way to put it.
It's just an incomplete hodgepodge methodology. You're capturing fragments of a conversation out of context, missing all the metadata. It practically guarantees a disaster during the discovery phase of litigation.
Honestly, I'd argue it's worse than a cocktail napkin.
Really? How so?
Because a napkin doesn't actively lull you into a false sense of security. What's fascinating here is the sheer informality of these apps tricks intelligent professionals into dropping their guard.
Because it feels like a casual chat.
Exactly. People use casual language, but the law doesn't view it as casual. Our sources highlight a recent case in the UK High Court where a simple exchange of WhatsApp messages between a client and a builder wasn't just seen as a chat.
It was a contract.
It was deemed an objective manifestation of assent. It created a legally binding contract. Furthermore, there is a rapidly growing body of case law proving that emojis carry serious legal weight.
A thumbs up is no longer just like, got it.
Right. A thumbs up emoji is no longer just an acknowledgement of receipt. Courts are actually construing it as formal consent to terms.
Wow. So we've established that those little green text bubbles are a data security nightmare and a total contractual landmine. But even if we could magically make WhatsApp 100% secure and legally unambiguous, we'd still have a massive problem.
The emotional blind spot.
Yes, the medium itself creates an emotional blind spot.
It strikes right at the heart of your duty to ensure a client actually understands your advice. When you strip away face-to-face interaction, whether that's in person or over a secure video link like Teams or Zoom, you lose the tone of voice.
You lose so much.
You lose micro-expressions, you lose body language. This isn't just about being friendly or building a nice rapport. It is a critical professional vulnerability.
Let's get into the mechanism there. Why does the lack of body language actually matter to the legal outcome?
Because human cognition is inextricably tied to emotional states. When a client is dealing with a legal issue, a divorce, a looming bankruptcy, maybe a hostile corporate takeover, they're usually experiencing intense negative emotions.
Anger, fear, confusion.
Or just feeling completely overwhelmed, right?
Mm.
And from a neurological standpoint, those emotional states actively and severely impair a person's cognitive ability to process complex information, give you accurate instructions, or make rational decisions.
The amygdala hijacks the prefrontal cortex.
Exactly. When you are sitting across from someone, you can see their jaw clench. You can see their eyes glaze over when you explain a complex indemnity clause.
You can pick up on a sarcastic tone.
Right, and realize they don't actually agree with the strategy, they're just shutting down.
And then you can pause the conversation, de-escalate, try explaining it a different way.
You modify your delivery based on real-time feedback. But if you were just sending a dense email or a quick voice note or a text message, you are entirely blind to their emotional state.
You might assume they've grasped a highly complex legal risk.
When in reality, they were crying or furious when they read your message and absorbed absolutely none of it.
And this collides directly with a major generational shift mentioned in the sources. The workforce, both your junior lawyers and your incoming clients, are now heavily millennials and Gen Z.
Very true.
And the research shows these generations vastly prefer digital-first communication. They love brevity, they love bullet points, they hate unexpected phone calls.
Oh, they despise phone calls.
Right. And they place a massive premium on psychological safety. So, what does this all mean when a Gen Z client's deep preference for brief, ephemeral text messages collides with a complex, high-stakes legal issue that requires deep understanding?
Well, it requires the lawyer to take control of the medium. Just because a client wants to communicate via Signal where messages automatically disappear or leave you a string of asynchronous voice notes does not mean you should oblige them.
Right.
You are the professional. You hold the malpractice risk. Therefore, it is entirely on you to say, look, I understand you prefer texting, but to protect your confidentiality and ensure my advice is legally sound, we must use our secure platform.
Okay, I have to push back hard here.
Right.
because that sounds great in a textbook.
Yeah.
But in the real world, if I tell a 25-year-old tech startup founder that they have to log into a clunky desktop portal to talk to me instead of just texting me on Signal, they're going to fire me. They will immediately find a lawyer who will text them. How do you balance professional standards with the harsh commercial reality of not losing your business?
It all comes down to how you frame the friction. You don't pitch it as a bureaucratic burden. You pitch it as premium, bespoke security.
Ah, okay.
You explain that their intellectual property or their term sheet is too valuable to risk on a platform that scrapes data. And crucially, you don't force them onto a clunky desktop portal from 2005.
Right, nobody wants that.
No. The solution is leveraging the right modern tools. You migrate that client to a secure, modern client portal systems like Lacadia, Clio, Leap, or Smokeball.
Which have great apps.
Exactly. They have sleek mobile apps. They offer the real-time updates, the push notifications, and that digital-first interface that modern clients crave, but they do it securely.
So documents are encrypted, communications are centralized.
And an audit trail is automatically preserved for your records. You satisfy their demand for a sleek digital experience without sacrificing your professional boundaries.
That is a crucial distinction. It's meeting the client where they are, but moving the conversation onto safe ground. Now, that need for frictionless speed brings us to the elephant in the room.
Generative AI.
Generative AI. This is the absolute peak of the speed paradox we are discussing. Lawyers are using AI to draft emails, summarize portal interactions, do incredibly creative things.
Oh, the use cases are fascinating.
Like, the sources mention taking a dense 20-page legal advice document and prompting a sandboxed generative AI tool to translate it into concepts a 12-year-old could understand, just to check for clarity.
Which is a genuinely useful application.
Yeah.
Using closed, secure AI systems to test the readability of your own drafting is smart. And just to clarify for everyone, a sandboxed AI means a closed-loop system where your client's sensitive proprietary data isn't being fed back out into the world to train the public model.
It stays walled off.
Right. But even within a secure sandbox, we have to look at the severe risks. We all know about hallucinations, the AI inventing fictional case law.
We've all seen those horror stories.
Yeah. And we know about the risk of generic verbosity, where the AI writes a perfectly grammatical 5-paragraph email that completely lacks your personal professional tone. But the source material highlights a psychological risk of AI that is rarely discussed, and it's called memory fatigue.
Memory fatigue. Let's get into the mechanics of that. Why does that happen?
It comes down to a neurological concept called the generation effect.
Okay.
The human brain requires the friction of synthesizing facts and struggling with word choice to build long-term neural pathways. If you sit down and actively synthesize a complex set of facts to draft an advice email, your brain is engaged. You are doing the cognitive heavy lifting.
So it's 6 you.
Exactly. If that client calls you unexpectedly 2 hours later, you know exactly what you wrote, why you chose a specific adjective, and what the strategic nuances are, because that knowledge has transferred into your long-term recall.
But if I just prompt the AI to do it...
If you simply hit a button, have an AI draft that email, and you just give it a cursory 30-second glance before hitting send, you have bypassed that friction.
Yeah.
The generation effect never happens. You are far less likely to actually remember what you told your client. Over-reliance on generative AI fundamentally erodes your active cognitive engagement with the material.
You become a passive editor rather than an active counselor.
Yes, and that leaves you incredibly vulnerable during a sudden client phone call, a tense negotiation, or worst of all, cross-examination.
Here's where it gets really interesting and honestly a bit dark. There is an anecdote in the sources that perfectly illustrates what happens when you combine this craving for speed, the emotional blind spot of text, and the cognitive bypass of AI.
This story is wild.
A director of a firm actually fired a legal assistant via a text message. And not just any text message. He used ChatGPT to draft the termination text, copied it, and fired it off.
It is a staggering lack of professional judgment.
And basic human empathy.
Absolutely. But it perfectly highlights the danger we are talking about. When you completely remove the friction of communication, you remove the empathy and the contemplation required to deliver bad news appropriately.
It makes me think of an analogy. Using AI to communicate like that is like using cruise control on a winding mountain road.
Oh, that's a good one.
Right. Cruise control is fantastic technology if you are on a flat, straight, predictable highway. But if you rely on it when the terrain gets complex and you zone out because the car is, quote-unquote, driving itself, you are going to crash.
You'll go right off the cliff.
Using AI to handle delicate, complex human communication without deep, active engagement is a lethal combination of speed and automation.
That analogy hits the nail on the head. The technology made it entirely frictionless to send that termination message, which meant the director didn't have to sit with the discomfort, the friction of having a difficult human conversation.
But the fallout was huge.
Profound. The resulting damage to the firm's reputation, the potential employment law liabilities, and the human cost to that assistant. Bypassing friction usually just defers the cost, with interest.
So, bringing this all together for you listening right now, we've gone from 1970s dictaphones to ChatGPT. We've looked at the data sovereignty minefield of WhatsApp, the invisible dangers of losing body language, and the neurological memory wiping effects of AI.
It's a lot to navigate.
It is. But if there is one ultimate overarching lesson to extract from all this source material, it's a simple two-word directive: slow down.
Slowing down isn't just about fulfilling an ethical duty. It is a vital act of strategic self-preservation.
Yeah.
The brilliant new technologies available to you, interactive PDFs, virtual whiteboards like Miro, encrypted client portals, they are phenomenal aids for explaining legal concepts and collaborating efficiently.
But they're just tools.
They're just tools.
Yeah.
They should never be allowed to override the time you need to review, to pause, and to apply your uniquely human legal judgment.
You know, it makes me think about where the legal industry is actually heading. We are rushing toward a future where every single lawyer will have access to instantaneous AI drafting.
Every firm will have rapid-fire client portals.
Right. And when speed and instant algorithmic answers become a cheap, ubiquitous commodity, what actually retains value?
That's the real question.
Something to ponder the next time your phone pings with a notification demanding an instant answer. Thanks for joining us on this deep dive. Catch you next time.
That's it for today's episode on LexiCast. If you're looking for more in-depth episodes that can also be claimed as CPD activities, check out our LexiCast CPD Plus page linked in this episode's notes. Follow us now to stay up to date, and we'll see you next time.